Yes, sir.
Good afternoon. My name is Seth Seagraves. I represent the appellant, Caprice Peete. And at this time, I would like to reserve 3 minutes for rebuttal time.
Okay.
May it please the court, we have put forward 6 total issues, 5 core issues, and 1 issue of cumulative error doctrine as the final issue. But today I would like to focus on 2 issues for brevity and to really hone in and clarify the main issues and the worst errors in this case. The 2 issues I want to hone in on are 1, the court's denial of the defendant's cross-examination into certain areas with the witness Octavius Peete, and 2, the remarks during closing argument from the prosecutor. The reason I want to talk about these things is because under the cumulative review analysis, I believe they're interrelated, and I think that they cut to a really core question that I want to put before the court. And that is, when propensity comes up in court, when evidence that could be considered propensity evidence is put before the jury, who gets to do that and how? Is it the defendant under a permissible constitutional basis, or is it a prosecutor in closing remarks using racial connotations and outright slurs to denote the propensity of the defendant? First, I want to turn to the issues with the witness Octavius Peete. First, a few facts. I know Your Honor's read the briefs, but this was a case where self-defense was raised enough that the judge instructed on it without the defendant testifying. That came in a few ways. 1, the witness, Kalia Davis, said that they were going into the neighborhood, they saw the decedent walking up the street, that they had a lawful, reasonable purpose to go to this residence. They went to the residence, and that Mr. Peete and Mr. Taylor went into the residence with no mention of Dontavius Edwards. And she said that while they were in the residence, Dontavius Edwards entered the yard of Caprice Pete's aunt on Wooten and was buck jumping or jumping aggressively, as she said. And she said that she was in fear because it seemed like he was preparing to fight. She said that when Mr. Peete came out of the house, Mr. Edwards got so close that they could have kissed, I think was her direct terminology. And then there was a tussle with Mr. Peete, who had a firearm at the time. This is seemingly odd because the state's theory was one of premeditation. But the state's theory requires Dontavius to go into this yard without anybody actually knowing he's going to go there to confront Caprice Peete. And as Octavius Peete testified, Dontavius Edwards was actually on his way to Mr. Beatty's house to smoke marijuana. Mr. Peete, as a witness, was someone who, for 3 years of litigation, was never on any witness list. That is in the record. That is in our arguments regarding Mr. Peete. Mr. Peete never went to police. He hid out on the scene, according to him, and never gave a statement. He was only called as a witness once the prosecution went to him in jail and talked to him, and then he was called for the sole purpose of saying that the decedent did not have a weapon. The reason the state wanted to raise that was because Kalia Davis and Caprice Peete both said that during this tussle, Mr. Edwards was reaching for his pockets. We raised 3 sub-issues under Mr. Beatty's testimony. Basically, we wanted to be able to explain the facts of his conviction for convicted felon in possession of a firearm. Because we believe that if the jury did not hear that, there would be a conceptual void, and it would be unfair for them to call somebody for this purpose without explaining the underlying facts. The first subpoint that I really want to dig into is the big one, which is the Sixth Amendment issue, our right to present a complete defense. That right is so broad and so complete that the Supreme Court has upheld people using hypnotic testimony or hypnotically refreshed testimony in order to present their defense. In this case, we were not allowed to get into the firearm that was in the underlying conviction, one that Mr. Peete was caught trying to hide and dispose of. To raise that constitutional issue, there's 3 steps under Glenn Allen Donaldson, or State versus Glenn Allen Donaldson, which is 2020 Westlaw 2494478. First, it has to be critical to the defense. And it was critical to us. It undercut our ability to question and cross-examine a witness that the state called for the sole purpose of saying that the decedent did not have a weapon.
So how would the fact that he had a prior conviction for possession of a weapon and the nature of that weapon have any impact on that?
Judge, it was very interrelated, and it became more interrelated as the state's direct testimony went, or direct examination went on, because the facts of the conviction occurred 6 months after the shooting. So the shooting happens. Octavius Peete is the only person at the time that puts Octavius Peete on the scene and sees Mr. Edwards. He leaves, never talks to police, and then he is caught 6 months later throwing a firearm out a window of a moving car in front of police. During their direct examination, the state was allowed to ask, did that gun have anything to do with this case? So that's why we raised the second sub-issue of, did it open the door? The state got to get into the underlying facts. The state got to talk about the gun from the underlying conviction, but we were not allowed to. It was critical to us because this was a case where we couldn't outright prove that the decedent had a weapon, because there was testimony that he had reached for his pockets, that he was apparently brave enough to come into the yard and confront someone who was said to have an AR-style rifle. We weren't able to even get into the fact of, well, if you were there and he didn't have a gun, and you were caught throwing a gun out the window 6 months later, and the state was allowed to ask you, was that gun from this case? How are we not allowed to cross-examine on that? We can't have a court system where the state can get into the underlying facts of a case, but we can't. And then the second prong on the constitutional issue is the indicia of reliability. That was an odd one because the state tried to raise it again and again and again and saying, we don't know if he actually threw a gun out the window. We don't know if that happened. And the judge, the trial court, took umbrage with that and said, I remember the plea. That happened. He pled to those facts. The underlying facts, the indicia of reliability is there because he pled guilty to them and stipulated to them in court. As to the interest in supporting exclusion, the state has raised that there is this interest in not bringing in negative character evidence against a witness. Almost every case they've cited regarding propensity is when the state tried to do it against a defendant. I don't think the state's interest in a witness looking good can trump a defendant's right to stand up to the mountain and to fight the state and to say, I deserve to put on a defense.
Okay, I guess I'm a little confused about something. Your position is that you wanted to get into the facts of this prior case to show propensity of the defendant, of the witness possessing a firearm?
Judge, not necessarily propensity, but to answer a question that the state raised, to fill that conceptual void under Reynolds, which was the state asked, was that gun in the convicted felon in possession case related to this case? Why would they raise that? Okay. How do we answer that for the jury if they say, well, that gun's not related to this case, has nothing to do with this case, and we're not allowed to say, well, what did you do with that gun?
Well, okay, because you kept talking about propensity.
Judge, and the reason I was talking about that is because
propensity evidence is not admissible.
That's true, Judge. Well, actually, evidence that could be characterized as propensity under Reynolds is permissible for other things.
Okay.
If it comes in for another purpose, such as to fill a conceptual void, or when the door is kicked wide open by the state. I understood the court's prior ruling, but then the state got into the underlying facts. That comes into fundamental fairness. How can we have due process if they can talk about it and we can't?
So you're saying 6 months after the crime?
Yes, Judge.
The witness throws a gun out a window, and yes, that's relevant to this particular case?
Because they called him for the sole purpose of saying that the decedent did not have a weapon, and then they asked him, did the weapon in the case 6 months later, did that have anything to do with this case? They're outright asking, basically, did you dispose of a weapon from this case? And I don't get to say, well, what did you do with the weapon that you were caught with? I just don't see how that can be fair, Judge.
Well, okay, now I'm confused. So the state brought out the fact that he threw a gun out of the car window?
No, the state asked about the conviction. They said the conviction was 6 months later. And they said the gun and the conviction from 6 months later, was that gun from anyone in this case? Did it have anything to do with this case? And he said no. And I approached between questioning and I said, Judge, I think you know what I'm going to ask. And he said, I saw you perk up, but it didn't open the door. It was so.
So counsel, when we look at the record, I assume it went something like this. Correct me, fill in the gaps here. But he said, Mr. Peete, you're a convicted felon, and that was for possession of a weapon by a convicted felon. But that gun in that case didn't have anything to do with the facts in this case. Is that basically what happened?
No, Judge, he actually used names. He said, you didn't get that gun from Caprice Peete or Terrence Taylor or anybody in this case. So he actually cut to the heart of the issue, which was, did you get a gun from Dontavius, and was it this gun? And so to impeach him, could I not then say, what did you do with the gun, if you're saying it's not his?
Was his prior conviction for throwing this gun out, or is that what they convicted him of, or did they find the gun?
They found the gun, but they convicted him. They charged him with tampering, and then he pled under those facts to convicted felon in possession of a firearm. And we had there's a offer of proof and a lengthy voir dire in there where I asked him specifically, the gun was found out the passenger side of the window. You were in the passenger seat. It was found next to the car. And he tried to duck and dodge on that, but the judge said point blank, I remember the plea, you pled to that. And the judge found that to be credible and reliable. He just was concerned that it was propensity evidence. And with that, I do want to point out one other thing on just the Octavius Peete issue. The standard is abuse of discretion. And the one core thing that we hit on was, did the court reach an illogical conclusion? And this is where evidentiary law and constitutional law butt heads. The judge said specifically in this case, it makes perfect sense that they should know this information exists. The judge said, logically, the jury should hear this, but the rules of evidence say I can't give it to them. That cuts to the core of what abuse of discretion would be, but really, it's a constitutional issue. We have to be able to impeach witnesses, especially when the state is allowed to ask about the facts of those cases. The last thing I want to talk about is the comments in closing argument. And the reason I couched that in terms of propensity was because the prosecutor in this case used a racially pejorative term as a white prosecutor against a black man. He called Caprice Peete a thug in closing argument. There's one case on point that says that may not be error. That case is from 11 years ago. It was from a different time frame. The case was the same prosecutor. A white prosecutor in a rural jurisdiction calling black defendants thugs. Under Galtz, I think sometimes we forget that Galtz, what was said in Galtz, which is the kind of the standard for prosecutorial misconduct in closing arguments, the key thing that the court said, arguments which rely upon racial, religious, ethnic, political, economic, or other prejudices of the jurors introduce elements of irrelevance and have no place in our courtrooms.
Well, maybe I'm just old, but I've never heard of thug having a racial connotation.
I provided some sources in the brief of how, especially because there's not really a Black's Law dictionary analysis of this, and I actually provided a few cases from other jurisdictions that examine this. The Webster specifically says that when a white person calls a black person a thug, especially when there was no 404B, there was no other instances that they raised that Caprice Peete was this career criminal or anything like that. He says, of course this neighborhood is dangerous. We've got people like Caprice Peete, or thugs like Caprice Peete, committing crimes. And this court doesn't have to find that that's error. The trial court found that it was error.
And the trial court, and here's my issue with this. There was a curative instruction that was given.
Yes.
There was no objection to the curative instruction.
Well, and Judge, he also ordered the state to retract, and the state did not retract.
But if there was a curative instruction, which there was no objection to.
Judge, that may have been my fault, because I don't know that.
Well, I know, but regardless of fault, when we're looking at this and the judge does a curative instruction and the lawyers are there and there's no objection,
Yes, Judge, and
then doesn't that kind of end the issue?
it would if there were not further comments. The problem was he went on to say that if the jury does not convict Caprice Peete, he will have gotten away with it, that they needed to do their duty. And I objected as soon as "do your duty" came out of your mouth, or out of his mouth, because it was objectionable under State versus Cawthorn, and I was worried about what was coming after it. I had just had my client called a thug in front of a mostly white jury.
Yeah, but, and again, I kind of, Judge Holloway mentioned it. I mean, if you get down to it, thug is a Hindu word.
That's true.
It comes from thuggy, which is
Yes,
criminals
Judge.
in India. And I'm not aware of, at least from our case law, that says that is in and of itself.
I think what puts it in a great context is if we consider what Dennis Galtz was called, what the name that Dennis Galtz was called in his closing, which was a criminal. A criminal. That was reversible error. That is the standard in Tennessee. We don't name call in our courts. Imagine if I got up in closing and said, "That's a racist. That officer's a liar." We don't do that. And this prosecution is held to a higher standard. And for that reason, and for the other reasons, this court should reverse. If there's no other questions, I would yield my time.
Anything else? Thank you.
Thank you.
Goldman State's working you a lot today.
Yes, Your
Five of them.
Honor. Good afternoon, Your Honors. May it please the court, Ronald Coleman on behalf of the state, this time filling in for Davey Douglas, who has similarly left our office and gone on to greener pastures. He is now at the Board of Professional Responsibility, so I hope to never see him.
I don't know how green those pastures are, but anyway.
This court should affirm because for a variety of reasons, the evidence overwhelmingly established the defendant's guilt. The trial court properly declined to dismiss a juror. The trial court properly exercised its discretion in limiting cross-examination of a witness. The court properly found that the state did not commit improper closing argument, and there is no cumulative effect of any errors. The defendant relies today on two of those arguments, so unless this court has any questions on the other issues, we're happy to rest on our brief for those as well. But turning to the first issue that was presented today, which is the limitation of cross-examination of Mr. Beatty, I think it's important, and I've got the transcript here because I think it's important to point out exactly what the defendant was requesting. The trial court asked the parties when this sort of came up and they had a discussion, and it says, the trial court says, and this is on page 304 of the record, it says, "You guys correct me if I'm wrong, but what the defense has stated is that they want to use this conviction, and not necessarily the conviction, but the specific instance of conduct, the prior bad act, to show Mr. Beatty is the type of person that gets rid of guns." And the defendant twice, both on page 303 and I believe 316 and maybe also 332, repeatedly says, yes, that I want to introduce this to say that because he has gotten rid of a gun before, he got rid of a gun in this case. That is the textbook definition of propensity, which is not admissible. There are two evidentiary bases that he argues that should have come in under, and then there's one constitutional. So to the evidentiary basis that this is a contextual explanation, this fills in the gaps, that's not what he said at trial. He said this should fill this in because it points out that he has propensity. It points out that he's the type of person to get rid of guns. That's not a contextual background. So the court properly found that that's not an appropriate basis. And then to the extent he argues that the state opened the door, again, when this discussion came up, the court clarified and he said he wanted to bring this in to show that Mr. Beatty is the person that gets rid of guns. It's for propensity purposes, not to open the door. And while the whole point of opening the door is to sort of clarify and make sure the jury's not misled. not to sort of allow the defendant to get in propensity evidence. So the trial court properly exercised its discretion in both of those situations to say, this just doesn't rise to the level. You're wanting to use this solely as propensity evidence, and that is not permitted. The defendant also argues that this violated his constitutional right to present a defense. But this was not critical to the defense. And in his brief, the defendant's only contention is that the test, and this is on page 41 of his brief, the testimony was critical to the defense because it was the one area of impeachment relevant to Mr. Beatty's testimony. Well, the record contradicts that. The defendant, in fact, did a thorough and honestly strong and strengthy impeachment of Mr. Beatty and sort of walked through a number of reasons why he might not be trustworthy and why the jury could potentially doubt it, and he raised those points in closing. So this was not so crucial to his entire defense as to where its limitation somehow precluded him from presenting that defense at all. That's especially true where his co-defendant Taylor's, I believe, girlfriend, who drove him there, also testified about what she saw with the victim and how she wasn't sure he was armed, but he looked like he was reaching into his pockets. So he was still able to present that defense even without this testimony. So ultimately, the trial court properly exercised its discretion in saying you don't get to go into these details of the underlying conviction for the purpose of propensity. Turning to closing argument, the defendant takes issue with two comments that the state made. His first complaint is that the state improperly called the defendant a thug. Whether there are racial connotations, whether it was proper or improper, is really irrelevant at this point because the defendant objected and the trial court sustained that objection. And in fact, what happened here is that the defendant got what he asked for. So this is volume 5 of the record, page 612. The court says, what do you want me to do? What instruction do you want me to give to the jury? And the defense says, I would like for you to state that this was improper and that they're to disregard it. And the court says, I'm going to say that they need to ignore his comment that Mr. Peete was a thug. That's what I'm going to say. And then he instructs the jury on this. The defendant obtained the relief that he requested. To the extent that this was improper at all, the court addressed it, granted the relief that the defendant wanted, issued a curative instruction, and because the jury is presumed to follow those instructions, there is no error here on appeal. Turning to the second comment, the defendant objected that this one the court overruled the objection, but it makes sense in the context. The defendant takes issue of the state saying that the defendant could still get away with this and that they needed to quote unquote do their duty. I think it's important to address the context of this. First, saying that the defendant could still get away with it. The state had made it its entire closing argument. In fact, the entire case was that they believed the evidence established the defendant's guilt. And so to say, well, if you end up, we submit that based on this proof, if you don't find him guilty, he will have gotten away with it. That's a reasonable submission, and it does not rise to the level of improper closing argument. And then to this do your duty, I think it's important to, again, address it in context, and specifically looking at earlier portions of the closing argument on pages 607 and 615. The state noted that the jury had a, quote, duty to come in and learn what a legal term means, listen when the judge defines predetermination. And so it was talking about this context of your duty is to be a good juror. Not, your duty is you have to send a message to the community, which this court has found is erroneous. Not your duty is to, stand up for all the people, all these innocent victims. It's do your duty, deliberate, and if you find the evidence establishes guilt, find him guilty. When included in the entirety of the defense of the state's closing argument and with the context there, it doesn't rise to the level of an improper argument. And then even if this court were to disagree and say that particular comment was improper, it certainly was harmless. The evidence here was overwhelming. It established that this defendant, his co-defendant Taylor, communicated via phone, arranged this sort of meeting, had someone transport each of them to this location where they were already armed. So they armed themselves before coming here. They go into this house after they see the victim. They sort of tuck away their weapons so no one sees it. But when they exit, as soon as the victim is coming, they exit fully armed, showing their weapons. The defendant walks up and hits the victim. They enter into an altercation, and then they shoot the victim multiple times. The evidence is overwhelming, and this comment of, do your duty wasn't so much so that it affected the outcome of trial. And then because the defendant briefly touched on cumulative error, there are no errors, or at most that one comment, if this court finds that one comment is error, that's not multiple, there are no cumulative errors, so he's not entitled to cumulative error relief either. I believe that's all I have for today. Unless your honors have any questions, we once again ask that you affirm the judgments. Thank you.
Thank you.
I want to touch just briefly on a couple of things. First, as to the state's response on the constitutional issue, the state was very flattering in saying that my cross-examination was a good and thorough cross-examination. However, we are not entitled to just a good defense, we're entitled to a complete defense. And that means when the state of Tennessee is allowed to open the door, we should be allowed to walk through it. And so on that issue, I would submit that the state did open the door, and constitutionally, we should have been allowed to ask Octavius Beatty the question that was left in the void, which was, if that gun has nothing to do with this case, where'd it go?
But then at trial, were y'all arguing for basically for propensity, that if he did it then, he did it before, he did it again?
There was a brief discussion. So we had 2 days of hearings on Mr. Beatty. The first day, I did, probably as an error, as a tactical error on my part, said, Judge, we should be allowed to, those are my words, that we should be allowed to show that he's the type of person that disposes of guns. And the judge said, this is really important. I do think that the jury probably should hear this, and this is a first-degree murder case. This could be close. We need to take the night and think about it. And I went back, and I looked at the law, and I came back with permissible reasons. The thing is that, under Gilliland and Reynolds, when the state wants to call somebody a gang member, that's okay. It's propensity evidence, but it's okay because it explains the void. It explains why they would do something like this. And so when we're talking about Octavius Beatty and we're talking about why would he be on the scene? Why would he hide from police? Why would he grab the decedent, leave, and then never talk to anyone about it for 3 years? I think that that's very analogous to when the state gets to do it to a defendant and call them a gang member. Because what there is there's missing facts that the jury needs to hear.
Yeah, but the missing facts can't be that you have the propensity for doing this.
But isn't that what gang membership is?
Not necessarily, no. But just saying because you did an act once in the past means you're going to do it again, and the jury should draw that conclusion.
Judge, in the abstract, I would agree, only if that wasn't the sole purpose that they called him for, and that wasn't the one thing that they asked, which was, you didn't find any guns, and the gun you did have didn't come from this case. It goes right to the heart of the issue, and I think it draws a void. Just briefly on the issue of closing arguments, the state in its brief and even in argument didn't argue that the term is not racially motivated or connotated. They just said that the prosecutor didn't have that intent. But Galtz is very clear. The danger is not the prosecutor's intent. It's the juror's prejudice.
But this goes back to, though, if there was a curative instruction that apparently met with the defense's approval, why are we discussing it?
Judge, actually, I'm out of time, but if I could be permitted to answer.
Sure.
I pulled the portion of our brief that covers the transcript, and the court asks my co-counsel, what type of instruction would you like? He said, I would like for you to state that Mr. Freeland said was improper and that they're to disregard it. He never said it was improper. He just said disregard it. And that any sort of larger issues may be implicated by a statement. We never got to finish our argument on that. The court cut us off and said, this is what we're going to do.
Okay, and then there was no objection then?
Judge, once they issue a curative, I mean, I could keep objecting to curatives, but
Well, I mean, isn't that kind of what we're talking about, is if you don't think the curative instruction is sufficient, don't you need to put on the record why you don't think it is, that give the judge an opportunity to correct it, as opposed to just saying nothing, and then after the fact, we're, oh, well, we didn't like it?
well, Judge, we did try to say something and he cut us off. It's in the transcript.
But that's not an objection.
We were in the middle of an objection when he cut us off.
Anyway, all right.
Thank you. Oh, and we would respectfully ask that you remand.
All right, well, I guess this is, completes our first day of argument. Thank you all for some good arguments and good briefs, and we'll adjourn until tomorrow.
All right.